Cool. Well, thanks everyone for allowing me to present here today. I should mention that a lot of these slides were cribbed from Brian Love's presentation that he's made. We made a paper jointly together that I'll be going over. And so I just wanted to give him credit, and I'm sorry he wasn't able to come here. He had a new child, and so he went on sabbatical. And so that's why I have the honor of presenting this paper. So there's three parts to what I'm going to be presenting. First of all is the paper that we made together. The second part is a quick update. So we updated some of the statistics from that paper because it's getting a little stale. And then the third part is some general observations about, and Suzanne Michelle mentioned some of that, about how patents are being used and IPRs are being used overall in litigation strategy. Okay, so this is the paper, and so we can talk about this briefly, but we stopped the paper actually October 1st, 2014, which is a while ago now, obviously. And we actually only studied the IPRs up to April 1st, 2014. And the reason why we did that was because we wanted to make sure that the IPRs had matured to the point where there was an institution decision or not, to be able to get accurate statistics on some of the kind of what was the success rate or not success rate. Some of the unique aspects of what we did was we looked at the MPE status, so non-practicing entity status of the players involved. And we looked at the tech classes, and we kind of defined the tech classes between different areas, whether they be medical, so we call them sectors. So not based necessarily on tech sectors as they're traditionally defined, but who the companies are that are getting asserted against primarily. Technology, like high tech, and then other, like mechanical type things. And then we also looked at parallel litigation for all the instituted IPRs. And so that was important because we wanted to see how this relates to existing IPRs. Let's see. So some of the interesting statistics that came out of that. I mean, I'm not going to go very deeply into this part because you guys can look these up anyways. You know, obviously the pending was very high because there was a huge bubble of IPRs coming into the system that we just didn't evaluate, essentially. There was, you know, 20% were not instituted, and we looked at on the merits or if it was untimely or duplicative, and what percentage settled. And we also looked at before institution and after institution where the settlements were. And one important thing, I think there's a couple important things to look at in these statistics for later is on the merits was only about twice as much as untimely or duplicative. And then on the after IPRs are instituted, the settlement rate was, you know, a little more than before institution, but not that much higher. And then final decision was 16%. We also looked at the duration, how long it took to terminate. So all terminated were 9 months, not instituted 6 months, obviously, because that's when the institution decision was made. And settlement was, on average, a little over the institution decision. And I think, you know, and this is not something that I know for sure, I'm just, you know, making my own kind of theory about it, is that, you know, companies back then didn't know, and this is basically in 2014, they didn't know how IPRs were going to come out at that point. So a lot of them were waiting to see what was happening with the chances of institution, and at that point they decided whether to settle or not. Now, I think some of this has changed now, and frankly, we are going through the process of updating the study right now, and my expectation is to see the settlement rate come in around 5 months now as opposed to 7 months, simply because people are tending to settle beforehand rather than later now. But I don't have those statistics yet. And then, you know, if you had to go to final decision, the average time frame to get that is 15 months. And, you know, another interesting thing, and I should mention this, is that we did do comparison, and it's in the study and in the paper that you can look up. And in the study, it talked about the difference between IPRs, re-examinations, and reviews, for example. And so it was 36 months for re-examination compared to review. And we also looked at, you know, the amendments. That question came up. Amendments were a huge difference, and we can go into that also. So this is what we calculated the institution rates to be. So the original institution rate was around 78%. But what we did is then we said, well, let's get rid of a couple different things. Decisions not to just institute for other various reasons like duplication or joinder issues. So we got rid of that. And then also, where there's a unique patent or there was another IPR that was involved that was involving the same patent, we got rid of that too. And in the process, we saw the institution rate, if you got rid of all of those, the institution rate goes up to 87%. The institution rate for reexamination was 93%. So it was pretty high originally. But again, there was a huge difference then on the amendment side. And so that we thought that was interesting. And then we looked at the claims. What percentage of the claims were instituted? So for the average IPR, out of 16 claims challenged, 11 claims were invalidated or disclaimed. That was just on a claim level basis, what we were looking at. Versus 61% of inter-party reexamination patents surviving with amended claims. Back then, there had been only one successful amendment, and that's where both parties agreed to it at that point in time. And it was the US government, I think, on both sides, if I remember correctly. But since then, there's been additional successful amendments, as I understand. But that's back then. And so I just have to, remind everyone this is like a study that ended in October of last year and really talked about, filings up to April of last year. Among IPRs with final written decisions or requests for adverse judgments, 77.5%. All instituted claims were invalidated or disclaimed, and 65% of all challenge claims were invalidated or disclaimed. So it's a pretty good number. And we compared it to reexamination again, which obviously is a timely question. And there, 31% of the reexaminations ended with all claims invalidated or disclaimed. And the rest of them essentially got amended. So there's a huge number of amendments that happened in reexamination in the past that just was not happening right now. And people argue either way on this. I think one argument on one side is to say, well, why should it be amended if it's in IPR? You can't amend in district court. Why should you be able to amend here? Another argument is that people should have the chance to change it. I think a counter to that is if it's in litigation, one of the policy issues that is, if someone is putting their patent into litigation knowingly, if we're talking about patent quality and improving patent quality, they have, I think, some of the duty to actually look at the prior art before they start filing these patents in litigation and suing people with them to ensure that it is good quality. And they have amended it correctly or taken care of looking at the claims in a way that makes sure that they're able to cover themselves because they are willing to put their patents out there then to play. And if you play, you can get hurt. So we looked also at comparing MPEs to what we call operating companies. So we compared the difference in what percentage of IPRs were against MPEs and against operating companies. It was about half and half. We looked at the institution rate. So the key difference here is the institution rate. I got 5 minutes, so I'll be quick. The institution rate was about 9% higher, and this is in 2014, compared to the institution rate for operating companies. People can interpret it any way they want. In the end, the bottom part among the instituted IPRs and the merits decisions, it's kind of a wash because institution rate is higher, but success rate actually for invalidating is actually higher against operating companies. And then we looked at technology areas, and it looked pretty uniform around all technology areas. There didn't seem to be very much variation between that. And so we looked at parallel litigation. And this was interesting. So 80% of all the challenge claims were currently litigated between someone. So we didn't look at a one-year difference, I think that was brought up here. We just looked overall. Is there a litigation involving this patent? And then 10% had never been litigated in any way. All right, so, and 10% had been litigated, but were no longer litigated, I guess you can kind of impute. And then we looked at stays. The grant rate, so we looked at stays a little differently. People look at stay rates differently well, they interpret it in different ways. We just looked at the final stay decision. So people have asked multiple times, a lot of times in a case for a stay, and we just looked at were they successful in the end getting a stay at some point in that process. And what we saw is Markman didn't really make a huge difference. And then it was much higher than your re-exam stay rate, obviously. And then these are actually directly the numbers. And you can see that there's about a 10% difference in the Eastern District compared to most of the other venues. But overall, most places could get stay rates. Markman didn't seem to make a difference. That was kind of something we were looking into. Sorry. So one other thing, so that was the study. Oh, 2 minutes, okay. So that was the study that we did. One thing I think to bring up, this is some additional, I think, good information for people to think about. And this is something I think Suzanne Michel was mentioning, and I think it relates to what he was presenting too, is what we did is we looked at, a question was all the litigated patents. We looked at all the litigated patents since 2012. We looked at all the IPRs, and we looked at the overlap between the two, basically. We got rid of all the repetition in it. So we just looked at unique patents that were in litigation and unique patents that were in IPR, eliminating all the repetitive IPRs and all the repetitive litigations. And what we saw is out of 13,000 unique patents, only about 12% were actually challenged at PTAB. So what we're seeing here is that 88% of the patents are not challenged at PTAB. That could be potentially through IPR. Now, right now we haven't gone to the claim level, but in this slide and the next two slides, we do go down to the claim level. And we look at the outcome of terminated cases. So these are cases where it could be a final decision, it could be settled, something happened along the way, it didn't get instituted, for example. And what we saw was around a 65% survival rate, 64% survival rate, which means if you had a claim in a patent, you had about a 64% chance of surviving, or it was at termination in some way, up to that point. And then we looked at final written decisions, and obviously in final written decision, the survival rate goes down much further, because at that point we're only looking at final written decisions and looking all the way back to see how many claims were at the beginning of that and going all the way forward. So I think that's it. And I have the updated stats, but for some reason I think this was the difference, but that's okay. But I'll quickly say then for the updated stuff, since I have 30 seconds, that we're going through the process of doing it right now. The institution rates have gone down according to the latest numbers that we are seeing, and there's a 6-month delay because we want the IPRs to mature in order to do that evaluation. So we're seeing it go down about 10%. Still, the institution rates between MPs and non-MPs doesn't seem to have changed a lot significantly. There's a 7% difference spread, but the invalidation rate's about the same between the different things. In the end, it's really, we think about patent quality and improving the patent quality in the system. And if IPRs can help that process, that's a great thing. And we think that there are different ways to do that using this and understanding better, actually, and this is the next research project for us beyond this, is to find out why things are getting invalidated and going back to the prosecution process to understand what's going on there in order to figure out, can we actually do it in a better way, or can people know why their stuff is getting invalidated more or less, or improve their processes for prosecution to get a better chance of surviving an IPR. Thank you.